Yeah, so we kind of touched on it when we were talking about the three different types of the dispute resolution mechanism. So the mediation versus the
Yep.
arbitration versus the litigation. A standard clause that I would recommend people use and certainly expand upon for your particular business is, let's say you decide that, okay, given the nature of my business, given that I want to protect my product, given that I want to maintain confidentiality, I want any disputes arising from this contract to be dealt with by arbitration. So you could have a clause that said, for example, all disputes arising under this agreement will be resolved exclusively through binding arbitration, conducted in accordance with the laws of, and you put in whatever jurisdiction, and in accordance with, let's say, the ADR, the word is missing me, something dispute resolution mechanism, right? So you want to make sure that you're specifically spelling out what is the mechanism, i.e. arbitration, which rules will govern. So for example, the rules or the laws of Ontario, and which arbitration rules will govern. So the rules of ADR.
So when you look at the locations, so say for example, you have business that, does business all around the world, and you say, I want to go by the rules of Ontario. Is there anything where that could be considered that you couldn't uphold that because maybe you do a lot of business proportionally in Florida, and so that vendor or that customer would say, well, no, we're going to use my laws because I'm the one suing you.
If it's not in the contract or if it's in the contract.
If it's in the contract.
So that's the thing. Like, you want to negotiate which laws will govern. Because if you are an Ontario resident or an Ontario business and you are familiar with the law and let's say you're the supplier of this particular product, it makes really little sense for you to agree to be governed by the laws of Florida if you don't have a connection to Florida other than you're shipping your products to someone in Florida, right? So, and there's a whole area of law called forms non-convenient, where people argue about, is this really the appropriate forum for this dispute to be dealt with? And so you don't want to find yourself in that situation where you're fighting with someone over what laws should govern before you even get in the fight about the actual dispute. So
And
be
how many
really
times do you,
clear.